Okay, this is ready.
Get ready.
Case number 23M00490FY, people of the, no, yeah, it is people of the state of Michigan versus Charles Henry Walker. Well, we got everybody but Mr. Walker.
He is. He doesn't know how to work his phone.
Oh,
He's there. If you say his name, he may hear you.
Mr. Walker, can you hear us?
It's ready to cross the opinion really important way will end. This is the permanent cessation possibility.
Hey, Mr. Walker, can you just state your name for the record?
Charles H. Walker.
Okay, good. And may we have other appearances for the record?
Good afternoon, Your Honor. AYOK here on behalf of the people.
Elizabeth Lippett on behalf of the people.
Okay, I can't hear Mr. Martin. Oh, something's going on there. Can anybody else hear Mr. Mertens?
No, Your Honor.
Okay. Well,
He said,
oh, you know, you got your earplugs in. It could have something to do with that. Okay, try it again. Okay, Mr. Martin, try to put your appearance on, please. Maybe you can't hear me now.
I'll check.
It seemed like as soon as he took the earplugs
You
off,
can hear him.
you could hear him, but now I can't hear him at all. Again. Oh, okay, well, wait for him to sign back in. Watch from Justin. All right, let's see if we can hear him now. Go ahead and try to place your appearance on.
Test 1, 2. Can you hear me?
Yes, good.
Fabulous. I apologize, Your Honor. May it please the court, Scott Mertens on behalf of the Department of Insurance and Financial Services, also known as DIFS.
All right, thank you, Mr. Mertens. And today is the date scheduled for a motion hearing in this regard, and it is brought by DIFS, the Department of Insurance Financial Services. And this was a motion for leave to appear. And then there's some other objections relating to the prior order that was entered by the court which was directed to the Department of Insurance and Financial Services to not, really to enjoin them from destroying documents. So I'll let you go ahead and make your argument there, Mr. Mertens.
Your Honor, may I put my appearance first?
I'll bet you did already.
No.
Okay, go ahead.
Wilma Hickey and Pete went back to the Bureau on behalf of Mr. Walker, who
I thought you did first, and then
President
Mr.
of the
Walker.
Bureau. Yeah, I just asked him to state his name when he was on. I apologize.
Okay, so now we're all here. And you want to go ahead with your motion, Mr. Mertens?
Thank you very much, Your Honor. Your Honor, I note that the Department of Insurance and Financial Services received this court's order to enjoin. And I also appreciate the importance of preserving evidence. After all, Mr. Walker is a charged criminal defendant, and there are certain rights associated with that. However, the Department of Insurance and Financial Services is a huge agency that services the entire financial sector, in fact, in Michigan, everything from insurance to banks to credit unions to pharmacy benefit managers to all kinds of areas in the healthcare space. Your order enjoins the Department of Insurance and Financial Services from destroying or in any way getting rid of any materials of agency-wide, regardless of whether or not it has to do with Mr. Walker. And doing so would require the storage of not megabytes or gigabytes, but terabytes of data at the cost of thousands of dollars to the state of Michigan. The fact of the matter is that Mr. Walker, as I understand it, and the Department of Insurance and Financial Services has little to do with the prosecution of this case. In fact, they're the complaining witness in this case. But the understanding of the Department of Insurance and Financial Services is that this is a matter of production and not necessarily a matter of preservation that requires the preservation of all these documents outside of the documents that are relevant to Mr. Walker's case. So we filed a motion, or I filed a motion, and it's kind of, it's a sticky situation. In my 24 years of practicing, I've never found myself in a situation like this. We titled it a motion for leave to appear because technically DIFS is not even a party to this. The parties in this case are the people of the state of Michigan, represented by the Financial Crimes Division at the Department of Attorney General, and of course the defendant. So really DIFS has no duty of disclosure, or they're not a party in this particular case. They're a third party, but because of the intricacies and the nuances associated with the court's order to enjoin, DIFS felt it was important to appear, to express and articulate their position regarding the breadth of the order and the impact that the order would have on their operations. DIFS wants to be a cooperating party. They want to facilitate the production of any and all materials needed for the prosecution of this case and for the defense of this case. DIFS recognizes and appreciates that the duty to produce that the prosecution has is not only the production of exculpatory or inculpatory information, but also information that might be needed for impeachment purposes. So what I have suggested in my motion to enjoin, Your Honor, or my motion to kind of modify or set aside the order is kind of a two-part thing. One, as it relates to preservation, let's narrow the scope of that preservation to anything that has to do with Mr. Walker or any entities in which Mr. Walker was affiliated with that was licensed with the Department of Insurance and Financial Services. If we narrow the scope of the preservation order to that, it's first of all, it's where all of the relevant information will be contained. Secondly, it will save the taxpayers of the state of Michigan thousands of dollars over the duration of this criminal case. So that would be the request as it pertains to preservation. As it pertains to production, the Department of Insurance and Financial Services will avail themselves in cooperation with DTMB, who kind of is the overseer of our technology services in the state, to make sure that anything that defense counsel is needed. So what that means is he would provide us with kind of search terms, custodian names, things of that nature. And after that is provided, we'd have DTMB conduct that search. We would provide all of the materials to the prosecution, who then in turn would produce those materials, presumably in a fashion that they deem appropriate, whether or not they have objections or not. We would produce it to them, and then they would produce it to the defense.
Okay, all right. So who wants to respond first? Mr. Payoff, did you want to respond, or did you want to respond first?
If they have something to say, they can say it.
All right, go ahead, Mr. Payoff.
Your Honor, I'm really only here to contest the dismissal part of it. I don't really have a dog in the fight as far as the discovery goes. One thing I can attest is that we agree we have the burden to produce Brady and Giglio material, and that just because it's in DIF's hands doesn't change that obligation. So if anything, that's our responsibility, and that's can't be transferred to DIF in any way.
Okay, well, you know what, if I kind of remember this, the way this order got entered in the first place, it seemed like to me, both the Attorney General and the defense were somewhat outraged that things weren't turned over, things were destroyed, and you both kind of agreed on the language of the order. I entered it in agreement with that. Now you're saying you really don't have a dog in the fight, but you seem very concerned that there were documents that you hadn't seen, or things that could have existed, that you were concerned that might have gotten, and I'm not saying purposely, but whatever, inadvertently destroyed. So I'm not sure how your position has changed such, but I'll let Mr. Mahikian voice whatever his concerns are with it.
Thank you, Your Honor. As I wrote in my reply, I think it's a bit disingenuous for the Department of Insurance and Financial Services to act as if they are a third party in this case. We have no discovery from police. The police were not involved in this investigation. Every piece of discovery that we've received has come from the Department of Insurance and Financial Services. This entire case comes from the Department of Insurance and Financial Services. I included an attachment where the Attorney General and the Director of DIF issued a joint press statement the day my client was charged, in which they included statements where they said this was a partnership and they're happy to work together in this partnership. So I think it's disingenuous to go from a partnership and knowing that every piece of discovery in this case comes from DIFs, for them to come in here and act as if they're a third party while making arguments on behalf of the state of Michigan while being represented by the Attorney General's office, the same office that's prosecuting my client. So I completely disagree with that position. I completely disagree that they are a third party here. Essentially allowing that argument would allow the police to come in with their own attorney to say, hey, we're handling the discovery and we'll decide what we give to the prosecutor. And really, that's the biggest problem is now it went from, we're going to get you everything. We're going to make sure we have everything. We agree that you don't have these things. You should have had these things.
No, that's what I remember.
To the Attorney General's office, literally screening the prosecutors in this case from the discovery process. They're not going to be involved. They're asking me to work with this third party in obtaining discovery for my criminal case. I have no duty to discover evidence that I don't have. I mean, that's the entire problem here is I've been finding things that I don't have, and I've been asking them for it. And it gets to a point where I say, hey, you need to do your job and you need to find these things for me. Like, it's not my duty to discover things I don't have in my possession. And to make things worse, instead of getting more involved in the process, which you would expect the Attorney General, the prosecuting side of the Attorney General's office to do, to ensure, hey, this doesn't happen again, we're going to make sure you get everything. Their office literally blocked them off. They're not looking for stuff. They're not contacting DIFs asking for things. They're going to be given stuff and then decide what to turn over to me. That's not how this works. They have an obligation under Brady to ensure that I get everything. They also have an obligation under the rules of discovery to ensure that I get these things. So in a sense, it went from we agreed and you haven't gotten everything to we can't even handle discovery anymore, and DIPS is a third party, and now they're asking me to work with a third party and give them search terms to find things that I don't even know what exists. Like that's the problem. I get documents, I find another document listed within a document, and then I ask for it. Like it's their duty, it's their obligation, and at this point, given the status of the Attorney General's office, and instead of getting further into discovery and making sure they have everything, they basically stepped aside and said, hey, we'll let DIPS handle it. Well, DIPS started this whole problem. They're the reason we're here. They haven't been giving us stuff. They didn't have an explanation why I wasn't getting these documents. So instead of digging into that, they've been ordered out of it. So I don't know how they can meet their duties as prosecutors to comply with discovery or Brady when they literally have been ordered by their own boss to stay out of it. So as far as I'm concerned, the only solution at this point is a dismissal with prejudice, which will in fact fix the problem that DIPS is having, in which they are spending thousands of dollars to secure data, ensure it's not deleted. Well, I guess my only response to that is, hey, if you want to get into criminal cases and you want to assist in prosecuting criminal cases, well, you need to comply with discovery. And to do that, you need to let the prosecutors in on what you have. I mean, this would never happen in a normal criminal case. There would never be a time where essentially the police are coming to the court, asking the court to remove an order and being represented by counsel other than the prosecutor. And as far as I'm concerned, Your Honor, this case should just be dismissed with prejudice, and then they can work on figuring out these cases in the future if they want to get into criminal prosecutions.
Pam, it's your, I mean, I'm kind of slightly shocked myself at the Attorney General's position because, you know, the Department of Insurance and Financial Services is not a party. We ordered, based upon an agreement that was on this record, that Mr. Mr. Nahiki, I'm trying to get your name out. Mr. Nahiki was finding things that the plaintiff didn't have. Things might have been destroyed, weren't clear what was going on, and we knew there was some type of process there, so that's where the origin of this order came. The parties agreed upon this, basically, and the court signed the order. Now, and it is the duty of the plaintiff to turn over what they have. How can you turn over discovery to a third non-party and ask the defense to work with them when if they're not responsible for that? The plaintiff is. If the plaintiff doesn't turn over information that they have or have access to, which they technically do because these are the records that everybody's supposed to know about, then they cannot proceed with the prosecution, or they're subject to a dismissal for under Brady or any other argument that could be made by the defense, because you're responsible for turning over those kind of documents. It's not the third party department. And since when do they have their own lawyer? That is a good question, because they're a party that apparently the AG office had worked with on some level. And so they would be the third party that the AG would have control over to some degree to get the documents from. I'm not going to hold them. They're not even a party to the case. They're just here arguing a motion. I can't hold them responsible if nothing is turned up. I got all the AG responsible. The AG has stepped back from what I'm hearing, which I didn't know anything about that part, basically, until it's argued, that you're throwing your hands up and you're throwing it over to an independent third party to give the discovery and to decide they're not prosecuting the case. They're supposed to decide what he needs, and he's supposed to figure out what he needs And he's been doing that to some degree because he keeps finding things. But it's the responsibility of the plaintiff when requested to turn over exculpatory materials and any other materials that would be relevant to the defendant's inquiry that they have access to. And there's nobody saying you don't have access to it. You're just saying you don't want to deal with it. Let the defendant deal with the third party. And I don't think that's right. I don't think that's how discovery is supposed to work. That's like if you wanted discovery from the defendant and I don't hold the defendant accountable for it. I say, well, you know what, defense, you don't have to turn over anything. Let's go to the third party that you've gotten some information from and hold them accountable for it. When, in all accounts, it would have been the defense that had gotten that information and had access to it from a third party that's not a party to the case. And usually, when you do have separate entities, they are witnesses for the prosecution, and they typically are, in that respect, represented by the prosecution. I'm not sure why we got now a separate entity, and I understand the argument about maybe the breadth of the order being, a little wide. I get that. But that's for the parties to figure out and work out and get that information and couch it in a way and agree to it. Not to step back and act like you're not a party to the case. And if Mr. Nakikian wants the case to, Mr. Nakikian, if you want to, I entertain a motion for that. Because right now I'm not happy with this. Not happy with the whole process of how this is turning out.
Your Honor,
So if you want to give a basis for them to file an actual motion that they can respond to dismiss the case, I'll consider it. What do you want to say?
Your Honor, that was me that interjected. I want to make clear that the suggested method of production was something that was suggested by DIFS to facilitate production. It was in no way, shape, or form impressed upon the Department of Insurance and Financial Services by the prosecution team. It was, again, just a means of facilitating production.
I understand that you suggested that, and I'm saying it's supposed to be their job to suggest whatever resolution of it in a way with these documents. It's not for the third party to come in and talk about it. It's for the prosecution, who this is your witness. And apparently, if they did have press conferences saying it's a joint effort, well, then you're working somewhat together. So the prosecution should have access and should understand and know what DIFS has. And I thought they didn't, and that was why they agreed in the first place. That something, we need these documents too, is what I think I remember them saying. We don't know what they are. And we want to stop them from destroying anything potentially that we might need. Now it seems like they've backpedaled on all of that and are leaving it in some way, shape, or form for the defense to try to figure it out with this. And so I'm going to leave you, Mr. Payout, to say what you want to say in this
Your
regard.
Honor, if I may first.
Well, hold on, go first.
As
Hold on a second.
stated by DIFS, they don't have a duty of disclosure.
No, they don't. And I don't have a basis without them being some kind of a party. I mean, I got an order right now that's in place. There's really no basis to say they violated the discovery order because they don't have a duty to give discovery. The parties do.
Right, and it's my understanding that the prosecutors have been ordered out of that process.
Well, I don't know if they have or not, but they seem like they backpedaled out of it, whether they were ordered out of it or not.
Well,
So what do you want to say?
Your Honor, I understand your perspective. Nobody backpedaled out of anything. Where we are, unfortunately, is we didn't have and have had trouble getting the material from DIFS, but we can only control what we can control. We told, I'm sorry, I'm getting some sort of feedback here and I don't know where it's from.
Yeah, we can't hear you that clearly either.
Hold on a sec, let me pull it. Is that better?
Yeah, you're kind of muffled sounding for some
Yeah,
reason.
there's something with the computer, unfortunately. I think.
Can you hear him?
Yeah, it's muffled, but
It's muffled. Is anybody else having trouble hearing Mr. Payout?
Yes.
Yeah, because I'm
Yeah,
barely getting your
try
voice.
getting further back.
Yeah.
Oh, yeah, no.
All right. I'm gonna try to sign in a different way.
Okay.
I'm trying to get on a different computer. I'm in the waiting room now. Can someone let me in from the waiting room?
Okay, let me, see. I should be able to get you.
Okay, can anybody hear me now?
Gotta mute the one.
Is that any better?
Yes.
Okay. All right. Anyway, so I apologize. We're not backing out of it. Unfortunately, part of this has been taken out of our hands. As we talked about at the last hearing, I had indicated that we would agree to this order, but we didn't represent diffs and didn't have any direct control over diffs. Now, I understand for purposes of Brady, and I understand for purposes of prosecution that we are in control over them, and so I don't dispute that at all. But for a practical purpose, we're having difficulty with that. When we brought this up to them internally, they got their own. What's going on now? So that's the way it is, unfortunately. Now, I agree that if there is anything that's exculpatory or problematic that is not turned over to the plaintiff, that is on us, that is on the prosecution, it's not on diffs. That's the case.
But I guess the question is in that regard, whose duty is it to find out where the exculpatory material is? It's sort of like you're putting it under the fence to kind of comb through and see if they think they see something that's exculpatory. And that's not their job. That's the prosecution's job to turn over anything. So shouldn't you be in it of looking through whatever you're looking through to determine what's exculpatory or not?
I agree with that. It is not the defense's obligation. That was not our idea. That wasn't anything that we brought up. As that is not the resolution that we want.
Can you ask them to explain what they mean by
So
it's been taken?
Yeah, I'd like to know that myself. What do you mean it's been taken out of your hands? I mean, if you can't proceed with turning over information, or at least finding out if it exists pursuant to a defense request, then what do you mean it's taken out of your hands? Then it seemed like to me at that point, the only resolution would be a dismissal. Because you can't act.
Well, we are, once Dick's got it.
Who took you out and what does that mean?
They have their own counsel, and their counsel is here. And right now, I don't have a way to directly to diffs for information.
In other words, diffs is deciding what to give the prosecution.
Well, how could that be? You're representing the people of the state of Michigan in a criminal case as the plaintiff, it would appear to me that that would be your responsibility to be able to access information from the agency. I know why they're here, because they're saying the scope of what, we tried to enjoin was too big, or too grand, or too broad. But the bottom line is now you're saying you have no access to their information at all. How can that be? And you want to proceed on the case? And the documents and things that they have appear to be central to some of the things that you're alleging. But you have no access to it?
Well, no, that is not the case. I need to distinguish a few things here. First, it's not that there's no discovery that's been produced. Thousands and thousands of pages of discovery have been produced in this case. So everything that was directly from the client has been produced over to Mr. Nahikian. Where we are is a situation where the defense that was raised made a lot of other things relevant to the case, a lot of other things that were potentially exculpatory. The defense is that there's some collusion or some intent to use a civil process to obtain criminal evidence or sort of criminal prosecution. So that then expanded the scope of what was there. It included documents that we would not have produced in a standard case because they're not directly relevant to the elements of the crime, etc. So since that has come up, we've been trying to get those documents as well. And that's where we found or continue to find that there are things that we didn't know existed. And I understand again, Your Honor, that's our obligation. I'm not denying that at all. We're still finding those things out. But my point as far as the case dismissal is that dismissal at this point would be premature. And there's two reasons for that. One, the third element of a Brady violation is that the outcome of the case would be something different than it would be otherwise. So that means in a standard Brady violation, the case has gone to trial or there's been some adverse ruling against the defendant, and then the Brady violation. I've been unable to find a single case where there was a Brady violation found and things were dismissed before the case went to trial. Secondarily, the discovery obligation, which we take seriously, is in Chapter 6.2 of the criminal rules, which takes place after preliminary examination is done, which is in the 6.1 chapter of the criminal rules. So in the standard case, unlike one of the larger white-collar cases we have, a preliminary exam is a quick and dirty. It happens within 14 days of the charge, 14 days of the arraignment. All of the defenses don't necessarily come out. It's a real quick probable cause proceeding, and they run forward. And discovery happens at the circuit court level. I'm not disputing that any of this has a right to.
Not really. From my experience, and I've been doing this for at least 22 years, and I've been practicing way longer than that, for about 40-some years. And I can say this, you're right, a lot of discovery does occur at circuit court, but in some instances, a lot of it occurs at the exam stage because, defense counsel want to be able to cross-examine on certain issues. And now he's raises real particular issue that could get resolved here. He's not bound to wait till circuit court to have that issue brought up, but he's raised it here. So to that extent, you're kind of incorrect because, real quick probable cause hearings, that's what we prefer, and that's what happens in many cases, but they're not so complex as this. This is a very complex case. It has been going on for days. And so in this type of situation, a lot of that discovery is going to be exchanged at the preliminary exam level, and the defense is not precluding from raising some of their defensive here. And this court's not precluding from them either.
and I'm not suggesting you are, Your Honor. I'm not suggesting that anything that's happened is inappropriate for preliminary exam. What I'm saying is there's no prejudice at this point to the defense. We haven't even bound them over yet. If it gets bound over to the circuit court. So we're not at a point where the delay in having these materials is prejudicing Mr. Walker's rights as they would arise in a criminal trial. We're not, that clock isn't running yet. We're not even in circuit court. So what I'm saying is, I don't contest the violations. I don't contest that the discovery hasn't been timely or been ideal at all. I'm just suggesting I don't believe that dismissal is appropriate yet for those reasons. Because there isn't, we're not at a situation. I'm sorry, go ahead.
Let me make it clear. I told him I would entertain it if he wanted to brief it. I didn't say I was dismissing the case today. You would have the opportunity to fully meet every argument that he makes if he briefs it. And whether or not, it's premature based upon the reason you have, you might have a good argument there. So, but I'm not saying I'm going to dismiss it now. I'm saying that I'm not clear on what's going on here and why. And I would be open to hearing his motion. That's what I said.
I understand. Okay. I misunderstood. As far as our interaction with gifts, my understanding is that they wanted to step in and try to have this hearing. We're certainly not giving up our obligation, but as far as the scope of the order goes, we don't have, that's what I was trying to say. We don't have a dog in the fight as far as the scope of the order goes. We do have, as far as discovery, yes, we're pushing that forward and that's what we intend to. But they wanted to resolve the order first to see what they actually had an obligation to preserve. We're not pulling up our hands as to that. It's just regarding the order itself.
Well, regarding the order itself, if we're trying to figure out what they have an obligation to preserve it, if that should be changed, it would seem like you would still have the ability to weigh in on that to some degree, because ultimately, if something is not produced that should have been produced or preserved that should have been preserved, you guys are on the hook for it. And so how can you just say, well, you know what, we kind of stuck because we don't have anything to do with the scope of the order? Because, well, yeah, you do from the standpoint of if he doesn't get what he wants and what he thinks he needs and what he's entitled to, he's going to be trying to then make his argument for sure. And then you're stuck with it because you didn't get involved enough to decide or to at least look to see if the documents were relevant, should be produced or not. You're kind of leaving it to the department to do that with him. And I don't see how you would even want to do that.
That's not the case, Your Honor. We've been involved in trying to get information from DIFS since at least I was involved in this case since last spring. It's been a weekly undertaking.
Yeah, and I get that. And I'm not saying that you totally just threw your hands up. I don't think you did, but at this point it was kind of sounding that way. And I guess my perspective on it is Mr. Nahigian was combing through, I don't know how he's been doing it, but he's got his documents all organized, and every time he gets something, he's been combing through it, and then he comes up with one other thing, and you said, yeah, we didn't know that existed. That looks relevant. What's going on here? Everybody was kind of like in agreement with that. And so at some point, who's going to make the determination as to what those things are? I mean, you guys going to wait for him to kind of comb through everything like that and put that burden on him?
No, that is not my intent. It's not his burden.
So you're not combing through it with this to try to figure out what's relevant and not? We
have been asking DIFS to comb through it. We have a pre-existing order in place to preserve everything that has to do with Mr. Walker. Right now, getting Mr. Mertens involved, hopefully we will have better access to DIF's materials. That is going forward. Because what we were doing, obviously,
Yeah, it wasn't working. Not at all. And so, well, and I was hoping what could happen here today was that the parties could look at the breadth of whatever the scope of this is, because, when I looked at their, motion, they're indicating, well, it's just not, insurance, and it's just not this defendant Walker. It's, they listed 26 HMOs, 87 banks, 139 domestic insurance companies, that they have regulatory enforcement authority over, and of individual licensees and entities, including Blue Cross and all these other things, 157 credit unions, 1,447 foreign insurance companies, 224,077 individual insurance companies, 18,239 insurance agencies, 8,668 mortgage licensees and registered, 616 deferred presentment companies, and 2,560 other consumer finance related entities. So this is more than what I knew, but I'm learning a lot about what DIFS does, what they have access to and control over. So that is a lot of documentation, and their argument has been, well, we want to get you anything, and I don't. With this defense, it's hard to say what specific document could be relevant. It's kind of hard to see it, I would think. But we could maybe say some of these things are just not going to be relevant at all. So I was hoping that the parties would be able to sit down and say, well, you know what? We agree some of these things probably might not be relevant, and we could exclude some of these things from the destruction order or the enjoyment order, because they probably wouldn't be relevant, just generally. I was hoping we could come to that.
I have no problem with that. The problem is they want me to work with DIFS on it. I'm not working with a third party. I don't have an obligation to. It's not my responsibility. It's not my duty. They're represented by the same office. So I would imagine that they'd be able to work on that with me. But instead, I've been directed to DIFS, not only for this order, but for discovery itself. And we found this issue back in October. I haven't gotten a single new document yet.
But I'm trying to understand how you could just turn over all your discovery requests to DIFS. All?
They were ordered to by their supervisors, is my understanding. That's the entire problem. Is they've essentially been ordered out of the discovery process.
Well,
now DIFS is going to review things, and DIFS is going to decide what to give to the prosecutors, and then the prosecutors will comb through what they get from DIFS and decide what to give to me.
This is really irregular. I've never seen anything like this.
Your Honor, I think that the defense counsel is misstating, first of all, what is being proposed and who is proposing it. And secondly, he is clearly confused about the way that the Department of Attorney General runs and what the roles and responsibilities of the department are. To be clear, DIFS is an executive agency under the supervision and control of the governor. The governor delegates supervisory authority to the head of the agency, in this particular case, Anita Fox. A criminal case is initiated by the Department of Attorney General, in this case, on behalf of the people of the state of Michigan, also known as parents-patriot litigation. That is done by the Attorney General at the discretion of the Attorney General. We have to create these walls because the Department of Attorney General represents a variety of different state agencies and also serves this criminal function as well. It is not uncommon, and I do mass court litigation on behalf of the state of Michigan. It is not uncommon that we have agencies on the other side of discovery disputes. It's the nature of the beast, and those agencies will be represented by counsel. And that's because, like in this particular case, DIFS has all kinds of rules, regulations, and statutes of confidentiality that they're obligated to follow that the criminal prosecutors would have no idea about. So there has to be this kind of threshold or this subject matter experts that kind of review everything before it goes out to ensure that their obligations are being followed. So I say that just to be clear about the roles of the different agencies and what the Attorney General does in a parents' patriotic capacity. Again, I want to emphasize the suggestion on the preservation or the suggestion on the disclosure piece or the production piece was just a suggestion. I have gotten into this case very, very late. I practiced criminal law myself for 18 years, doing exactly what defense counsel did in some of the nastiest cases you can imagine. I appreciate the effort that he has engaged in and the fight that he has engaged in. I understand it. I am empathetic. That's why I'm trying to facilitate production. I am not trying to get in the way or hinder the prosecutor's obligations or responsibilities in this case. In fact, I have no idea procedurally what has happened from day one. I don't. I'm just trying to come in and be a problem solver on behalf of DIFS at this juncture. I understand based on the prosecutor's representations that there has been a breakdown in some communication. I want to facilitate that communication. There, some folks have dropped the ball regarding disclosures or production. I want to fix that. That's why I'm here. I'm here hopefully to solve problems, not to create problems.
All right, well, I appreciate that. So I guess I'm wondering, Mr. Payak, since you are the primary plaintiff here, and we do want to get these documents, whatever we need to get from this, why can't you all work along with Mr. Nahikian and Mr. Mertens to try to figure out what it is that you need? I mean, I don't want to see Mr. Nahikian being the only one trying to fight for this and trying to figure this out, when ultimately I don't think that that's his responsibility. I do want to make sure that the burden is not on the taxpayers of the state of Michigan to have to deal with this, enormous brevity, the enormous breadth of this order. And I think that we don't have to do that if we can narrow it down. But I just think the two parties involved should be both involved in trying to figure out how to narrow that down. And then what we might be talking about. And I don't know who's looking at documents on behalf of the Attorney General. I just know Mr. Nahikian's been looking at the documents from his perspective and has been coming up with these things. And I would just think equally that somebody's reviewing documents, the same documents, and coming up with, the same thing Mr. Nahikian is, things are missing, we didn't know that. And then going both of you, if that's the case, to DIFS in order to try to see if they can give you what you want. And if we can stop destruction in a more limited manner on certain things. I came up with some things and I don't even know if they're good enough myself. But I shouldn't have to do that when we're talking about the parties. But I'm thinking, maybe we could limit this to just no destruction of documents, relating to just insurance agencies generally. Maybe that's broad enough, but still limited to do what we need to do. Maybe we can also say no documents should be destroyed if we're talking about investigations of insurance agencies broadly. Maybe we can also say no destruction of documents relating to any audits of insurance agencies. That's pretty specific, but probably broad enough to deal with what the issue is here about this investigation. Maybe we can say no destruction of documents related to the designated responsible licensed person of the DLRP, I think it is. Maybe we can say that. So that's an issue here. And maybe we could say nothing destroyed if it relates to enforcement of the statute, the specific statute that we're talking about in this case. And maybe we could then also say no destruction of documents that relate to the names of the witnesses, defendants, and the agencies of the defendants, which is somewhat what Mr. Martins had said, anything that relates to anything that the defendant is connected to. And then we could possibly say no destruction of documents with names of people or individuals involved in the audits, the investigation of the defendant or his agencies. And those are just some I just came up with, we threw out there. But it does seemingly carve out, some of these, other matters, foreign insurance companies or individual insurance agents. or insurance agencies. I mean, maybe we're hitting some of those, but maybe we're limiting it to some degree. And that's just what I came up with. But I'm like, well, what is it that you people think is relevant that could still get everybody what they need, still preserve the resources of the state and the state taxpayers so that they're just not stuck with terabytes and terabytes of data that they can't move or do anything with. And that Mr. Nahikian's not the only person trying to comb through things to work directly with Mr. Martins to try to get documentation. I mean, it would seem to me it's not that difficult for the plaintiff to be working with Mr. Nahikian and then everybody going directly to Mr. Martin saying, this is what we came up with, or this is what we're looking for. That's my suggestion.
We'll have to resolve the wall issue on our side internally. But I have no problem with that.
Yeah, and it seems fair because
we can deal with the defendant and then try to we'll go back with the list. And if Mr. Mertens is okay with that, then that's how we'll handle it.
And then the scope of some of the things that I've said might be realistic, maybe not, I don't know. But at least it defines some things, because before we just had some pretty broad language there. What did we say? We said the facility ensure discovery materials and potential exculpatory evidence is not deleted or purged by diffs. The courts enjoining the Department of Insurance and Financial Services from deleting or purging any and all information during the pendency of this criminal case. So that's like everything they do. And that does seem a little bit broad, but that was the language you all worked out. This includes the automatic deletion of information from diffs, automatic deletion through Microsoft 365 Lifecycle, automatic deletion of records and documents pursuant to the standard retention and disposal schedule. And that's probably overly broad because they got probably a lot of things that don't even relate in any way, shape, or form from what I'm seeing they do to this issue, this case, this defendant, the issue of the defenses generally. And it applies to information, documents, communications, and data in possession of diffs, including information unrelated to the case. Well, you might have to have some information unrelated to the case because it could be related to the defenses, but we don't know that. But at least we're trying to limit this scope of this. And because I understand the department's the quandary that they're in.
Your Honor, might I make a suggestion? And I only interject because until I started working with diffs, I had no idea what the heck diffs covered or what was under their broad umbrella. But perhaps for purposes of where we're at right now today, an order is entered that requires diffs to engage in a search of Charles H. Walker, Charles Walker and Associates, and the Walker Insurance Agency Group, or whatever entity that Mr. Walker has allegedly operated under. We can engage in a department-wide search of those entities and preserve anything with those entities' names on it. On top of that, we can enter a preservation order in the insurance sector. Now, I'm going to go back, and the Director Fox is going to bite my head off probably because it's still going to be overly broad, but at least it gets us, at least it allows us to release additional information, saving a bunch of money. And if we do that, in my opinion, I mean, that's still an incredibly broad, preservation.
Well, I don't know he can respond to it, but from my perspective, from what I'm hearing, he's been arguing or looking for is, the whole idea is the fact that what have they been doing with these other potential investigations of others? And at least in one instance, that is more insurance, I'm assuming. It doesn't go over into what's the other area?
HMOs, banks, credit unions. I think we can agree that.
The problem is that they issued an order to a bank, so I don't know if that goes.
They
to the
issued a
banking
subpoena to the
authority.
bank council. I think we've discussed that.
Right, and I don't know if that goes through a department, if it's
It does
just
not.
through.
And I've made that, I've indicated that to you, council.
I'm just supposed to take Dick's word for it, despite the fact that I've been told from the AG and from Dick's that I've received everything. I've been told that like 20 times,
Yeah,
so.
and then we find that you haven't.
Right.
20 times.
So now,
Or 15
now
times.
I'm supposed to rely on this and just say, hey, hopefully nothing's in this section. And hopefully, even though it's been 7 years since he was investigated in 2016, meaning that things are actively being deleted, that those things are contained within the insurance portion. But for some reason, I'm not
Well,
getting
I,
them in
you
the
know
first
what,
place.
I don't know what the answer is to that, because I don't know how you're gonna know that without going through every department that they cover, looking for things that you think relate, and that's very burdensome on anybody, including you.
Right.
You, them, anybody.
And the
So there's
other.
gotta be a way to determine, and I don't know what that way is. What's the scope of what the banks and the HMOs deal with? Because, I mean, you really think the HMOs have something to do with this case?
None of them do, Your Honor. Realistically, I understand and appreciate his defense is fluid and probably could evolve over time, and that's expected. That happens in a lot of cases. But to sit here and say that, I mean, it's. Why don't we issue a preservation order against the Department of Transportation, just in case? How about Treasury, just in case? I mean, at some point, we've got to be limited by reason. And I am suggesting something incredibly broad. Insurance is incredibly broad. That encompasses domestic insurance, foreign insurance companies, individual insurance agents. It covers all the insurance agents. I mean, that is.
That's sort of what I had suggested here, in a sense. Relating to agencies, investigations by agencies, audits of agencies, deal RFPs and agencies, and the statutes of the case, and witnesses, and any defendants and agents of defendants, and individuals involved in the audits of the agencies. I mean, I was trying to make it as broad but limited as I could myself. It sounds like he's kind of trying to propose something similar. Can't you all talk about this and get this language together, and maybe we can adjourn this hearing to a reasonable date where we can come back with an order that makes sense?
I'm on behalf of DIFS. I'm happy to facilitate that in any way, shape, or form that the parties deem appropriate.
And then, Mr. Payoff, you have to do that and go deal with your wall.
Yes, I understand. So we'll follow up immediately today, and then I'll follow up with Mr. Nahikian in the next few days.
Okay, so how much time do you want? You want something before the end of this year?
Well, we have a hearing on the 5th. I was gonna ask that we adjourn that, considering I haven't gotten any new discovery since October.
Okay.
But if we keep that date, I can try to work with both,
Well, the 5th is like
prosecution-
next week.
Right,
You think you're gonna be able to go through this by next week?
at
Maybe.
least for the order.
For the order?
Term.
I mean, I'm good with that if that's what you wanna
Or
do.
we could wait until the 17th where we have another
You have
hearing.
another date on the same, yeah, we picked a couple dates. So what do you wanna do, Mr. Petty? You wanna try for the 5th, or you wanna go to the 17th?
What we can try for the 5th, at least have something in, because I want to get this done sooner rather than later.
Okay, so that's what we'll do then. And that way we're not holding up the whole DIFS agency for months with this. So we can try to get it done by the 5th. And let's see if I can find my assistant. Well, actually I can look at the file, because that was at 1:30 on the 5th. So that's what we'll do. We'll come back to 1:30 on the 5th, and I'll make a note that the parties are going to prepare some language in the order enjoining destruction that's more reasonable. And And then I'll make a note also that Mr. Payak is going to get with his powers that be so that he can take a more active role in this because he's a party. It's ridiculous to me. Why we wouldn't even have to ask that. But you see if you can get your wall knocked down so that you can take an active role with Mr. Nahikian and Mr. Mertens to kind of identify this, work with this order, and then identify the kinds of things that you think you need from the people would need to see too. Because you're ultimately responsible for it if it comes up and you didn't produce it. So trying to avoid that.
I'd ask that Mr. Walker be allowed to appear via Zoom for the 5th.
Yeah, Mr. Walker can appear via Zoom.
Thank you.
And Mr. Mertens, you know, you can appear via Zoom as well. And,
Thank you.
and if you guys have out, then, you know, Mr. Payak and Ms. Lippert can appear via Zoom. I really don't mind because we're not taking testimony. At that point, we're really just working on this issue.
I have no.
All right.
Yeah, because they're all out of state, out of the metro area, and Mr. Walker has transportation issues and things, so, okay. All right, so gentlemen, look at, that is where we are today, and guess we'll be back in another week or so, by the 5th to see what we've come up with. So try to enjoy your holiday, but I think you're gonna be working.
Thank you, Your Honor. I need to, I'm gonna be late.
Thank you.
Okay, so that'll